Can a state's governor really do that? Does a state's governor have that kind of power? That's the topic of today's lecture today. And that's a topic you've seen in the news lately, have you not? Can you think of a state, for example, in the last 30 days that tried to recall its governor? Of course you can. Can you think of state governors who, for good or for bad, have come to the attention of the President of the United States? Have you heard the U.S. President take the bully pulpit and complain by name about particular state governors? Yes, you have. So what are the limits of a governor's power? What can a state governor do and not do? Where can a lawyer like you and I step in and draw the line when it comes to the power of the executive branch of state government and that chief executive of state government, the governor? That's the topic of our lecture today. But before we get to that topic, you've always been kind. You've allowed me to start every class with a prayer, and I thank you for it. I'll take advantage of that liberty again, and I'll do it once again. As you know, we often start our prayer with a little reflection about our great profession, the profession of the practice of law. And in those reflections, I've had a theme. I've asked you to consider whether it could be true for you that our great profession, the profession of a lawyer, could be something more than just an honest living, and could be something more than just service to our fellow men and women. And I hope it doesn't offend when I say just service to our fellow men and women. Obviously, our brothers and sisters deserve our service. But the reason I put just out front is to challenge you to think whether we can consider the profession of the practice of law a great profession merely because that profession serves our fellow man. I mean no disrespect to any other profession when I point out that any other profession can make the same claim. Those other professions also serve our fellow men and women. I have a little bit of hair left. And when I get it cut by a barber, that barber is in a profession that serves his or her fellow man or woman. I pulled the plug. I no longer have cable TV. But back when I did, just like you, I sat around for hours waiting for the cable guy to show up. When the cable woman or cable man finally got there and fixed the cable, of course that was service to our fellow men and women. Same can be said of realtors. Same can be said of accountants. Same can be said of any honest walk of life. And I mean no disrespect to the honest walks of life when I say that service to our fellow man is a rather low standard to meet, especially when it comes to our great profession, when it comes to the practice of law. The world is imperfect. I don't have to give you examples of that. You've experienced them in your own life. But think of the place of our profession when it comes to the potential for making the world a better place. Can any profession make the world a better place? Well, of course, but I suggest this. Our great profession, the practice of law, has a greater ability to make the world a better place. And whether it was Jesus Christ or Spider-Man's uncle who said it, with great power comes great responsibility. Am I right? I think both of them said it, if I paraphrase either one. So what claim of greatness is our profession if we merely point to the fact that what we do is service to our fellow man and woman? Every profession can make that claim. What my theme is and my challenge to you is that you should consider whether the practice of law, while being service to our fellow man and woman, can also be a service to the Lord our God. That's the higher calling that I challenge you to consider. And because of a lawyer's place in our society, I would be remiss if I asked for anything less, would I not? So for that reason, I give you this theme. And if you've agreed with me, then you've asked yourself, well, how do I do that? And last week, I discussed what I proposed might be the first step, and that was prayer. I suggest, for the reasons I talked about last week, that the first step has to be prayer. And I suggest that the first step must be unceasing. We must always and everywhere give thanks to the Lord our God. But today I ask this question. If prayer is the first step, what is the second step? Stated somewhat differently, is prayer enough? Is prayer enough? Ultimately, the answer can be yes. Nothing is impossible with God. So yes, prayer can be enough. And we can find ourselves, either now or later, in a station of life where perhaps prayer is the greatest thing we can do to serve God and to help our fellow man. I call myself a member of a prayer group called the MI, founded by St. Maximilian Kolbe. And the highest ranking members of our group, if we were to rank one another, would be the knights at the foot of the cross. You are not eligible for being a knight at the foot of the cross unless you suffer from what society would call a physical disability. If you are suffering like the Blessed Virgin Mary did at the foot of the cross, then and only then can an MI member call herself or himself a knight at the foot of the cross. If that is your current state, please know that the Lord hears your prayers, and prayer can be enough. But is that your current state? Can you do more than just pray for a better world? Can you yourself do more than just pray and hope and trust? Can you also be the physical answer to the prayer of another? Is that within your physical capability? For many of us, the answer is yes. So for many of us, prayer, though unceasing, is not all we can do. What then are we called to do as lawyers? And I put the answer on the board because I'm afraid I might mispronounce the word. Hope I haven't mispronounced too many words. Long story short, I got a bad jaw and I mispronounced some. But hopefully I do not mispronounce this answer, this second step that I propose to those of you who can do more than just unceasingly pray. You must be a lawyer who is thoroughgoing. You must be thoroughgoing. And what exactly am I saying? What do I mean by suggesting that the lawyer must be thoroughgoing? What I'm suggesting is that you must be not just the best lawyer that you can be, but that the best lawyer that a lawyer can be. That's what I suggest you must aim for if the practice of law is to be service to God. Think of your client. Think of your client's needs and your client's cause. Does your client just deserve a good lawyer? Does your client just deserve a great lawyer? Think of the Lord your God. God loves you just as you are and loves you too much to leave you that way. part of service of God is to try to serve God with perfection. Be thoroughgoing in your service to your client and in your service to the Lord. If there are statutes that need to be read before your legal task, know them like the back of your hand. If there is case law precedent that might be at issue, read it again and again so that you understand it. If there are tangential issues that might arise, be on top of those details. Leave no stone unturned in your research. Be nothing but the best in this town, as in so many others. If I were to throw a stone down a busy commercial street, it would hit 20 lawyers before it landed. Lawyers are a dime a dozen. Your client and your God deserves more than just a good lawyer, deserves more than just a great lawyer. Be thoroughgoing and make it your goal to be the state of Florida, to be the nation's leading authority in the area of practice that you choose. Be nothing less than the leading authority. Never stop educating yourself about the law. Never quit taking continuing education classes. Always be on top of the latest statutory amendment. Always know whether there is a case pending before a court of competent jurisdiction that could affect your practice. Be nothing less than fully, and I suggest overly prepared for the legal task at hand. Be thoroughgoing in every aspect of your legal practice. Now, I hear what you're thinking. That sounds good, but how do I do it? That sounds good, but can I do it? And the answer is no. You can't do it, or at least you can't do it alone. But I have good news for you. You need not do it alone. Commit your works to the Lord, and your plans will be established. Surrender your will, make your will God's will, and God's will be done. You need a co-counsel. A co-counsel who can help you along the way. Where do I find this co-counsel? If you know the truth, then you know that Christ has conquered everything, even death. Your co-counsel is in heaven, but your co-counsel is not dead. Perhaps you have loved ones who have died. They are in heaven. They are alive to Christ, can hold his hand, can whisper in his ear, and just as we see illustrated in the book of Revelations, can present your petitions directly to the Lord our God. Today, as I talk to you, September 29th, relevant to all of us because in the Catholic Church, it is the feast day of the archangels, St. Michael, St. Raphael, St. Gabriel. Relevant to me for that reason, and for one other, that it would be my mother, Joan Marie McGinley's birthday today, if she hadn't already passed. Perhaps you have a parent who's passed. My mom, St. Joan of Winter Park, as I like to refer to her, passed away in 2005. I know, sounds like an eternity ago. But if you've lost a parent, you probably agree with me that there are days where it still feels like yesterday. even if it was a lot of years ago. If I need someone to fight for me at the gates of heaven, I know my mom, St. Joan of Wood Park, will do it, because she fought all her life. She was an amazing woman. She met my father, Patrick, when he picked her up in his taxi cab in New York City. She was late for work. And my dad, Patrick, must have been a smoother talker than me, because I would have never gotten the digits in that situation, but I guess he did. While they were still engaged but not yet married, Mom had the first 6 of her 7 strokes, leaving her what I guess what we call today is disabled. But Mom was a fighter. The mom I knew was in great physical health. The mom I knew was ambidextrous. She could write with either her left or her right hand. I had no idea as a child that was because her physical therapist wasn't sure that she'd ever be able to write with either hand, so the therapist was trying to teach her with both. I was born in 1971. And when I was 3 years old, my dad had passed, leaving my mom with me, my sister Alice, and a mortgage. In the early 1970s, when job opportunities for women weren't the same as they are today, and they need to be even better today, and where job opportunities for the disabled were not the same as they are today, and they need to be better today. But I never went for loss for anything. I always had great food. Still enjoy great food. Love to eat great food. I always had clean and newish clothes. Maybe they weren't designer clothes. And although Mom didn't find an employer, she always found employment. She had to stay home with me and Alice. So she did daycare. Other kids would come by the house. Their parents were off to work, and they'd pay Mom for daycare services. Not only do we have income, but I had great friends to play with. I also had great dogs to play with. I didn't understand that Mom was doing that as a business too, selling purebred puppies. But that was Jo Marie McGinley. That was my mom. Always a fighter, always creative, always thoroughgoing in her ability to provide for me and Alice despite the obstacles. Mom's in heaven. Maybe yours is too. Maybe your dad is too. Maybe your grandparents are too. Maybe your friends are too. And they, through the love of Christ, are as alive today as they were then. They can intervene for you. Don't forget them in your prayers, because they won't forget you. And don't forget the angels. Will God send his angels? If your will is God's will, then God's will be done. We've all seen the cute little angels like the cherubs, right? See them on the Valentine's Day cards. They're so cute and cuddly. But I'm not sure that's what a lawyer needs. What a lawyer needs are the angels whose feast day is today, September 29th. Angels like Michael, Raphael, and Gabriel. Michael the archangel, you read about him in the book of Revelation. He led the good angels, threw down Satan. The lawyer needs St. Michael at the lawyer's side. Perhaps you need strength in your practice. Christ will provide it. Turn to St. Michael, and he will deliver that message to the Lord. Perhaps you need victory against all odds. Christ can provide it. St. Michael could cast down Satan. Imagine what he could do for you in your practice if only you ask and Christ provides. Think of the archangel Raphael. You read about him in the book of Tobit. He accompanied Tobit. He opened the eyes of Tobias. For the lawyer or law student who needs vision, who needs to understand what to do next, what type of practice to be in, how best to spend one's time, how best to serve client and God. Who better could Christ send, if you ask, than an archangel like Raphael? But with all due respect to the powerful Michael and the great Raphael, oh, how I love Gabriel. You know the story of the virgin who was visited by Gabriel. Hail Mary, full of grace, the Lord is with thee, says Gabriel. And that virgin, the Immaculate Mary, was confused by the greeting. For the lawyer who wants to know what to do next, perhaps Christ can send Gabriel. For the lawyer who's not sure what the best argument is, what the best direction is to take, perhaps Christ can send Gabriel. But if you need even more help, all the saints are available to you in heaven. Indeed, the Queen of Saints and the Queen of Angels is available to you. The one who heard Gabriel's greeting, the Immaculate Virgin Mary. As Christ hung on the cross, he said to the beloved disciple, "Behold your mother." Interpret that scripture broadly, please. Who is the beloved disciple? Look in the mirror and accepting that title, behold your mother. Every good God's grace can be delivered to you through the Virgin Mary. Never hesitate to turn to her. But ultimately, if you're going to be thoroughgoing in all of your practice, in all of your service to your fellow man and woman, and in your service to God, you're going to need the ultimate co-counsel. For that reason, this is my prayer for you and for all my fellow lawyers of goodwill. May Christ be your co-counsel. May Christ be your co-counsel. And if you can do what the Virgin Mary has done so perfectly, if you can surrender your will and then align your will so perfectly, so undeviatingly with the will of the Lord our God, then why wouldn't Christ be your co-counsel? The next step in transforming our great profession into more than just service to our fellow man and woman, transforming it into service to God, is to be thoroughgoing and to invite Christ into your lives, which means into your practice of law. And my prayer for you is that Christ may be your co-counsel. And if you're willing to do it, perhaps your prayer for me could be that Christ could be my co-counsel. And with that, as always, I pray in the name of the Father, of the Son, and of the Holy Spirit. Amen. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come, thy will be done, on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive those who trespass against us. And lead us not into temptation, but deliver us from evil. Hail Mary, full of grace, the Lord is with thee. Blessed art thou among women, and blessed is the fruit of thy womb, Jesus. Holy Mary, Mother of God, pray for us sinners, now and at the hour of our death. Amen. Pray for us, O Holy Mother of God, that we may be made worthy of the promises of Christ. Amen. In the name of the Father, Son, Holy Spirit. Amen. So can a state governor do that? What are the limitations upon the executive branch, which is the governor's office, right? And the cabinet, right? And those agencies created thereunder, right? What are the limitations upon executive power in a state like Florida? The first and primary source you want to look to is the topic of our class, Florida's Constitution. And indeed, we need to look at Article 4 of our state constitution. Now, right there, we see a difference between our state's constitution and the federal constitution. Which article in the federal constitution do we look to for the powers of the federal executive branch? Article 2, right? But here in Florida's constitution, we're going to look at Article 4. And let's do that. Let's literally look at the language of Article 4. There'll be some flipping of the screen back and forth here today. I hope that doesn't make anybody dizzy. Instead, you can follow along with me on your own monitor, or hopefully you can make heads or tails out of either the big board or the board on the left, or, hey, who broke the board on the right? Is that not the second week in a row where that one's blown out? Come on, who didn't pay their tuition? I know, I can't blame y'all. Okay, so we're looking at which article now in Florida's Constitution? 4, all right. Article 4, executive. Let's take a look. And what do we want to look for here? We've got at least 13 different subsections. I've got a little roadmap for us over here. What we're going to look for is this. Section 1 will be where we start. The things I want to highlight for you in Section 1, first and foremost, is that we've got a supreme executive and a commander-in-chief. Under the federal constitution, we give that individual the title president. Under Florida's constitution, we give that individual the title governor. Subsection B allows the governor to initiate judicial proceedings in instances where others cannot. That's different than the federal constitution, and indeed different than most state constitutions. Subsection C is going to talk about advisory opinions. Typically, you need a case in controversy. Typically, you need standing. What we're going to see through the operation of subsections B and C is a unique state constitutional basis to avoid the requirement of a case and controversy and arguably the requirement of standing. Subsection D, we're going to see where the governor is allowed to call out the militia. Talk about a powerful individual, right? In a democracy, you want the power to be the vote, and you must be leery of the fact that the power could become the army, right? Subsection E, the state of the state address. Subsection F, certain jobs can be filled by appointment. This is true in a recess appointment under the federal constitution, but we have a different type of appointment authority under Article 4, subsection 1 of Florida's constitution. Those are the things I want you to pay attention for and to look at with me as we return now to the text of Article 4 of Florida's constitution. So subsection 1 gives us a governor. The supreme power shall be vested in the governor, who shall be commander-in-chief of all military forces of the state not in active service of the United States. So does our state governor have a standing army? Essentially, yes, unless and until called up by the federal authorities, right? The governor takes care that the laws be faithfully executed. Interesting. We see a similar phrase in the federal constitution. But what have we seen under the federal system? We've seen an executive who sometimes decides that certain laws aren't going to be enforced. Can you think of any news reports you've seen in the past weeks or months or years where a problem seems to have arisen because the federal government executive branch has decided they're just not going to enforce a federal law? And if you're being honest, then the answer is yes. You've seen those problems arise. The federal constitution says that the president shall take care that laws be faithfully executed. We don't know in the federal system whether that's actually something we can use in a court of law to get a federal law enforced. And we have similar language here in our state constitution, and perhaps similar controversies can arise. Here we've got the governor may require information in writing from all executive or administrative state, county, municipal officers upon any subject relating to the duties of their respective offices. So when it comes to government accountability, can the governor get answers about what's going on with these other sovereigns. And that's probably a wise use of the term. We've already covered or touched upon municipal law. We've seen that a municipality has lawmaking abilities under Florida's Constitution, right? We've seen that a municipality can create committees, agencies, right? We've seen that there are school boards. We've seen that there are various subnational units created by municipalities or under the authority of municipalities. Whether or not that particular unit is under Florida's governor's authority is not directly answered by Article 4, subsection 1, but whether or not they are accountable to is directly answered insofar as that the governor may require information in writing from any of these entities, whether they're county or municipal, whether it's an officer or the county or municipality itself. Now, the governor, under section 1 of subsection 13 of Article 4 of Florida's Constitution, shall be the chief administrative officer of the state responsible for the planning and budgeting of the state. Does that mean the governor passes the budget? No, the budget is part of the lawmaking of Florida's legislature using the procedures you've already studied. Ultimately, a budget would go on the governor's desk where the governor might sign or veto that budget. Subsection B talks about the governor may initiate judicial proceedings in the name of the state against any executive or administrative state, county, or municipal officer to enforce compliance with any duty or restrain any unauthorized act. Question: does the governor have standing? If the governor believes that a duly elected official who has been elected to a county office or a municipal city office is not doing her or his job. And the answer, I would suggest, is quite clear from Article 4, Section 13, subsection B, that the governor can bring such a suit. What if the governor isn't sure what the law means, especially if the governor is in charge of faithfully executing those laws? That's where subsection C comes in. And it's that difference I pointed out a minute ago. Let me scroll up so we can see subsection C. Here, the governor may request in writing the opinion of the justices of the Supreme Court of the state of Florida as to the interpretation of any portion of Florida's Constitution or any question affecting the governor's executive powers and duties. What does that mean? That means the governor could file a suit, usually an action for a declaratory judgment, directly with the Supreme Court of the state of Florida. The suit begins at Florida's Supreme Court. Not this week while we study the executive branch, but next week while we study the judicial branch, you'll see how odd it is for a suit to begin at the state's highest court. But that oddity, if it is one, is allowed by this subsection C. Is it allowed to everyone? No, it's not. What if a county or a municipal officer has a similar question? They don't know exactly what the law means. They are not sure exactly how to faithfully execute that law. Can the municipal or county officer file suit with the Supreme Court of Florida and get an advisory opinion? No. Can you and I, as private attorneys, file suit and get an advisory opinion, either with the Supreme Court of Florida or any lower state court within the state of Florida? No. We can't get advisory opinions because of the case and controversy requirement and because of the need for standing. Courts aren't supposed to be law schools. Courts aren't supposed to be places for theoretical debate. Courts are supposed to make real-world decisions involving real parties whose rights and fortunes and freedoms are directly affected by the outcome of that lawsuit. So they're not supposed to be theoreticians or acting theoretically. Instead, the courts, are supposed to be deciding cases in controversy. But here's an exception. Now, who can go to the state of Florida's highest court, Supreme Court of Florida, and get an advisory opinion? If you're meeting with a client that needs such an advisory opinion, how do you know if this person is eligible? Real simple. Ask the client for a driver license, okay? Then go to the website and pull up the name of the current governor of the state of Florida. Do you have a match? If not, then that client can't get an advisory opinion. All right, so you know the procedure now. You got it? Okay. Subsection D, the governor shall have the power to call out the militia to preserve the public peace, execute the laws of the state, suppress insurrection, and repel invasion. Interesting. We think of some of those duties, like repel invasion, to be the duty of the federal government. There are those pundits who lament that in particular states at particular times, maybe the federal government isn't doing a good enough job of doing such a thing. If that state has a phrase in its state constitution like we have here in Article 4, Section 1, subsection D, then that state's governor can literally call out the militia and do something about it. So that can be among the powers of a state governor. Can a state's governor do that? If you've got a constitution like this one in the state of Florida, the answer can be yes. Here's subsection E. The governor shall, by message at least once in every regular session, inform the legislature concerning the condition of the state, propose such reorganization of the executive department as will promote efficiency and economy, and recommend measures in the public interest. That's subsection E. What's that talking about there? It's talking about the State of the State address. You've heard of the State of the Union address, right? The president makes a big show of that in most years. It's usually something that preempts whatever it was you really wanted to watch on television. Instead, you got to watch the State of the Union because it's on every channel, right? Well, maybe not on every channel, but you can find on the internet the governor's State of the State address. Here's one from March 2nd, 2021 from Governor Ron DeSantis.
Mr. President, Mr. Speaker, members of the House and Senate, fellow citizens.
Have I got my DeSantis voice down?
I see in many parts of our country, sad state of affairs, closed schools, businesses shuttered, and lives destroyed. This calamitous reality is just the beginning of what will likely be long-term damage to children, families, and society. Sow the wind, reap the whirlwind. While so many other states kept locking people down, Florida lifted people up. Florida schools are open, and we are one of only a handful of states in which every parent has a right to send a child to school in person. So you see, although the State of the State address might not preempt your favorite television show on every network, it can be just as dramatic, right? And I don't know, I, for one, as the father of an 11-year-old and an 8-year-old, I'm thankful that they can go to school in person with friends, and most importantly, with a live teacher who can give them some instruction. I know that adults can learn and can learn well through distance learning, but I'm not so convinced that's best for an 11-year-old, and I'm absolutely convinced that it's not best for my particular 8-year-old daughter. It didn't work as well for her as live instruction did. So I, for one, am thankful that I reside in one of only a handful of states in which every parent has a right to send a child to school in person. I'm thankful for that. But that is what we're talking about when we talk about Article 4, Section 1, subsection E, and how the governor of the state of Florida shall, by message at least once in every regular session, inform the legislature concerning the condition of the state. That has evolved in a similar way to the similar requirement in the federal Constitution. Just as the federal Constitution evolved into a State of the Union address, state constitutions have evolved into a State of the State address. Subsection F tells us when a way is not otherwise provided for in Florida's Constitution, then the governor has this power. The governor can fill by appointment any vacancy in a state or county office
for the remainder of that term and for the remainder of the term of an elective office if less than 28 months. You can read the rest there. Otherwise, until the first Tuesday after the first Monday following the next general election. I mean, why did they put that? Of course, it's otherwise until the first Tuesday after the first Monday following the next general election. We all knew that, right? I jest. Sounds nonsensical, but it works. So compare that to your prior knowledge. Compare that to your knowledge of the federal Constitution. And I like to do that because you come to this class with great knowledge of the federal system, right? So I want to help you understand our state system by comparing and contrasting. So what under Article 2, which is the executive branch article of the federal Constitution, what appointing powers does the president have there? Well, recess appointments. You remember recess appointments. If the Senate is in recess and an appointment wasn't made, then the president can make an appointment which endures until the Senate next is in recess, right? So we've got recess appointments. And they may endure even longer than that, you don't know. That's the federal system, one of recess appointments for the chief executive called the president. What's the state system? And the appointment power of the chief executive called the governor. There, assuming it's a term that's not longer than 28 months, the governor makes an appointment and that person's got the job because of the vacancy. And that's true not only for a state office, that's also true for a county office. As my fellow lawyer, this will concern you when it comes to the judges you appear in front of in our state court system here in Florida. So what if the county court judge was reelected and there's a year and 2 months left in the judge's term and the judge retires or the judge passes away or I don't know, the judge disappears? I haven't seen that happen in recent history, but I guess could. So for whatever reason, there's a vacancy there. Now the governor's going to make an appointment and that person gets to fill out the vacancy. Did you, as a voting citizen of Florida, vote for that person? No. Now there are some constraints when it comes to the governor filling a judicial vacancy, and that constraint is the Judicial Nominating Commission. The governor must choose a name that is given to the governor as the result of a Judicial Nominating Commission sending those names, sending that list of names to the governor. So that helps us a little bit. If God forbid we ever had a corrupt governor who was appointing their brothers and sisters and favorite donors, they could only do that if their brothers and sisters and favorite donors happen to be on the list that came from the Judicial Nominating Commission. So it's an imperfect way of preventing cronyism and paybacks and things of that nature, but at least there's some protection there. Any questions about Article 1 before we move on to Article 2? No, but maybe you've got midterm questions? As I have on the big board there. Yes, we will discuss the midterm, but I'm going to do that at the end of class. So have your questions ready. Articles 4, Section 2 and 3 is our next topic. Here's the things you want to look for there. We're going to be talking about the lieutenant governor. No, the title's not vice president, but by analogy, that might be the closest analogy. The lieutenant governor, you'll see, has duties as assigned. You'll see that the lieutenant governor becomes governor upon vacancy of the governor's office and in one other instance, upon impeachment. Note that it doesn't say upon impeachment and conviction, it just says upon impeachment. Also note this procedure for docketing of a written suggestion of incapacity. You'll note these things when we turn to the plain text, which I'll scroll over to over here. We're looking at sections 2 and 3. Section 2 says, there shall be a lieutenant governor who shall perform such duties pertaining to the office of governor as shall be assigned by the governor, except when authorized by law otherwise. and such other duties as may be prescribed by law. Yeah. So what's the lieutenant governor got to do? Whatever people tell the lieutenant governor to do. That's what the Constitution of the state of Florida says anyway. So it doesn't sound very prestigious for the plain text of Florida's Constitution. But of course, a given governor might give a given lieutenant governor a very important task to do. Likewise, the legislature might meet and assign such an important task. Until then, lieutenant governor remains, I guess, one heartbeat away from the governorship, I guess. So, anybody heard of a state lately where a governor fell from grace? Maybe the governor was so popular as to be winning, I don't know, Emmys or Grammys or whatever actors usually get, but the governor was getting them instead, and now the governor's out. Was it a palace coup? Was the lieutenant governor trying to get the governor's job? Heck, who knows? But I guess that potential exists in any state, right? Whether that actually happened recently or not, who knows? But I guess the potential exists in any state because the lieutenant governor remains a heartbeat away from the governor's seat. Subsection 3, succession to office of governor, acting governor. We're talking about here succession by the lieutenant governor. Subsection A says that upon vacancy in the office of governor, the lieutenant governor shall become governor. So that's where that phrase heartbeat from the presidency, or I'll co-opt it and make it heartbeat from the governorship, arises. Further succession to the office of governor shall be prescribed by law. That's different than our federal system, right? We've got a little more guidance in the text of the U.S. Constitution than we do in the text of the Constitution of the state of Florida. A successor shall serve for the remainder of the term. So, if the term's a week and a half, probably there's an election already set. If the remaining term is 3 years and 11 months, do we rush and set a new election any sooner? No. No, we don't. We wait 3 years and 11 months for the results of the next election. But here's an interesting difference versus the federal system. It's here in Article 4, Section 3, subsection 2, where it says, upon impeachment of the governor and until completion of the trial thereof, or during the governor's physical or mental incapacity, the lieutenant governor shall act as governor. So look at that again. It says upon impeachment and until completion of the trial, the lieutenant governor shall act as governor. Compare that to the federal system. If you've watched the news over the past year and a half, you've seen at least 2 impeachments of the president of the United States, right? Once while the president of the United States was president of the United States, and then again while the president of the United States wasn't president of the United States. I'll leave that to you as to whether or not it's good to impeach someone who's already left the office. But you've seen impeachments. And while the impeachment went on, at least while you're impeaching someone who actually is president, does that person stay president? Or does the impeached president say, oh, shucks, I was just impeached. The vice president is now in charge. I'm going to go focus on my trial and see if I can beat it. Well, you know the answer. The answer is, because you've seen it in the past year and a half, the answer is that if you impeach the president of the United States, the president of the United States remains the president of the United States despite the impeachment through the process of the trial. And then if the trial does not remove the president, then, president remains president. That's not how Florida's Constitution works. Here's how Florida's Constitution works. If the Florida House of Representatives affirmatively votes and impeaches the governor, that vote of impeachment means that the lieutenant governor shall act as governor from that moment forward. Then the impeachment trial of Florida's governor moves to the Florida Senate, where if the Florida Senate impeaches and convicts the governor, then the governor never returns to the office of governor. Instead, the lieutenant governor continues to fill out the term. On the flip side, if the trial in the Senate results in the acquittal or failure to convict of Florida's governor, then upon that vote, Florida's governor resumes the duties of governor, and the lieutenant governor then is no longer the governor. Is that system better or worse than the federal system? Maybe you could argue either way. Maybe from the perspective of the impeached governor, it would be worse. Here's a person who's been duly elected to the office by the people and now can't exercise the powers of that office. Not because they've been convicted, but just because they've been impeached. By analogy, it's like saying, oh, the grand jury indicted you, so therefore we're going to treat you like you're guilty unless you prove yourself innocent. Seen from that perspective, maybe you could argue it's unfair to the governor. What about from this perspective? By doing it the way Florida's Constitution does it, the governor now has been liberated from the governor's other duties and responsibilities and can focus full time upon the task of getting herself or himself acquitted, winning the trial in the Senate post-impeachment. I don't know, maybe that's an argument in favor of Florida's system over the federal government system. Or think about this one. Say you've got a president who's making a phone call to another nation, which is common because that other nation is a democracy and that democracy just elected a new leader. So as customary for our presidents, that newly elected Democratic leader will get a call of congratulations from the president, nothing illegal or immoral or unusual there. And some of the language of that phone call is at issue. So that president gets impeached for having made that phone call and gets impeached at a time where something really big is happening in the world. It's circa December 2019. There's been an outbreak of a thing in a nation which soon is about to spread worldwide and change the world as we know it. Other nations have leaders and legislatures who can focus on stockpiling some of these things that are now commonplace, but might have been hard to find back then. Might be able to take proactive measures about the forthcoming problem. But our nation is tied up from December 19 through about February 2020 with bigger issues such as, do we impeach? So we don't have stockpiles of these things when we need them. Maybe from the perspective of the elected who need a government focused on the real issues, not the political ones. Maybe from that perspective, Florida's system is better. And again, this is just a matter of opinion. Opinions are like noses. Everybody has one. Maybe you don't like mine. I don't know. But I try to get you go, raise the interest here. Try to make you think about these differences, whether or not they're good or bad. So that's what we see in subsections 2 or 3. We also want to look at subsection 4, and this is a very different system that we see here in the state executive of Florida versus the federal executive of the White House. After a president is elected and takes the White House, what's one of the first priorities of that president? To choose a cabinet, right? With the advice and consent of the Senate. But it's not like the Senate's got 2 choices and they're picking the better one. And it's certainly not like the president has no choice. I mean, no person's going before the Senate for potential approval unless the president has chosen that individual, unless it's the president's choice. Is that the same here in Florida, under Florida's Constitution, when it comes to our chief executive, when it comes to the governor? Well, if you look at the text, you'll see that it is not. Here in Florida, the cabinet of the governor is composed of 1 attorney general, right? 1 chief financial officer, and 1 commissioner of agriculture. Did the governor pick those? individuals? The answer is no. They ran on a ballot too. And statewide, the people of the state of Florida voted, not yes or no, like the federal Senate votes, but in a partisan fashion. There's an attorney general who claims to be the Republican nominee, another attorney general who claims to be the Democratic nominee, and many other attorney generals who either claim to be the nominee of their party or who claim to be independent. Who put those names on the list? It wasn't the governor. It was the party system. And who made the choice as to who is Florida's attorney general, Florida's chief financial officer, and Florida's commissioner of agriculture? It was us, the voters of the state of Florida, who chose them. Now, can that mean, for example, that you might have a Republican governor and a Democratic attorney general and an independent chief financial officer and a progressive party commissioner of agriculture? Yes, it can. We never see a White House, almost never, where the president picks individuals from another party to add to the president's cabinet. The president can. That would be the president's choice under the federal system. But we always have the potential of individuals who weren't chosen by the governor and may not be in the governor's party. Comparing again, president to governor. The president's elected with a mandate. It makes certain promises that the voters hope that president will keep. Governor most likely does the same. The president will have a cabinet, if chosen well by the president, which advances the president's agenda and that mandate from the voters. Will the same be true for Florida's governor? Maybe, or maybe not. The governor might have a attorney general here in the state of Florida that opposes the governor's platform, might have a chief financial officer in great opposition to the goals of Florida's governor, might have a commissioner of agriculture who would like to see the governor get impeached and removed. It can be a big fight in the hen house of the governor's mansion here in the state of Florida. So that's a potential disadvantage to an elected cabinet. What are the advantages? Why would the people of the state of Florida have drafted this into the 1968 Constitution, have enacted this Constitution of the state of Florida in 1968, and never have amended it ever since? Why is it there? What's the advantage? Well, one of them is accountability, right? In the federal system, if you don't like this appointee or you don't like that appointee, I guess you can hope to get rid of the president, who you then will hope will give us another appointee. But you can't really do something directly about the appointee you don't like. Here, you're voting as a Floridian on who's going to be in the office of Florida's Attorney General, Florida's Chief Financial Officer, and Florida's Commissioner of Agriculture. So you've got direct accountability to the voters. And who knows that? Well, the Attorney General, the Chief Financial Officer, and the Commissioner of Agriculture know that, right? They know they better be on the good side of the voters, of the electorate. They better make the voters happy. So you've got greater direct accountability. If there is an advantage, then perhaps that's what it is. What's the Attorney General? That's the state's chief legal officer. Interestingly, one of the things the Attorney General can do is write an advisory opinion to elected officials of municipalities. Remember how Florida's governor could, and only Florida's governor could, get an advisory opinion from the Supreme Court of the state of Florida, but elected county and city officials could not, and citizens could not, and corporations could not, and everyone else who's not the governor could not? Well, if they are elected to a county or city office, they can get an advisory opinion from the Attorney General's office of the state of Florida. Now, that's not the same as a court order from the state's highest court. And indeed, you've seen in our studies, we did study from at least one Attorney General opinion. And I warned you how it's persuasive but not binding. So it's some help, but not the same help as getting a binding court order from the state's highest court. The chief financial officer is the chief fiscal officer of the state, settles and approves accounts against the state, keeps all state funds and securities. Commissioner of Agriculture shall have supervision of matters pertaining to agriculture, except as otherwise provided by law. In an agrarian economy like Florida's has always been, and continues to be, despite tourism being so popular, despite all the other things. Agriculture is very important to our state. Now, the governor is the chairman, the chief financial officer, and the attorney general, and the commissioner of agriculture. Nope, sorry. The governor, chief financial officer, I'll highlight what I'm trying to say here, and the attorney general become the state board of administration. The governor, the attorney general, the chief financial officer, and the commissioner of agriculture become the trustees of the Internal Improvement Trust Fund. The governor, the chief financial officer, the attorney general, and the commissioner of agriculture are the agency head of the Department of Law Enforcement. Then there's the Office of Domestic Security and Counterterrorism. Notice sometimes there weren't 3 members, there were 4. Florida's Constitution says if there's a tie, 2 versus 2, the side that had the governor's vote is the winner. So in those instances where there were 4 members, not 3, if the 3 who are not the governor are going to beat the governor, those 3 have to vote together as a block. Those 3 have to be unanimous. Because if the governor wins over even 1 member of the cabinet, then it's 2-2 and the governor wins. The governor wins over 2 members of the cabinet, then it's 3-1 and the governor wins. If the governor wins over all 3 members of the cabinet, then it's 4-0 and the governor wins. So you see, there's a lot of ways for the governor to win. And the only way for the governor to lose is all 3 cabinet members stay together as a voting bloc. Interesting dynamic, isn't it? Are you still awake? Would you like a break? Let's do that. Let's take a 6-minute break. Then we'll wrap up this chapter. We still got to meet and thank our lead counsel. We won't neglect to do that. Did we thank Alejandro for a great job last week? Did you get a round of applause? Because you deserve it, man. Well done, sir. So will today's lead counsel also earn a round of applause? We'll find out after the break. We'll also wrap up this chapter and move on to the question of this. Do you have any questions for the midterm that I can answer for you? So I didn't forget the midterm. All right, see you in 7 minutes. Let me see if I can get some relaxing music for you to play while you're on your break here. I was looking for, and I think I found something that I can play in class. It's not copyrighted. Did I bookmark it? I hope I bookmarked it. Gosh, I've got so many bookmarks I can't tell. I'll look for it and try to find it again. Oh, you got a question?
Yes.
Yeah.
So I checked the Excel sheet.
Yeah.
I was signed in for last week, and then
So that's really great.
and then I went this week, and I wasn't there.
Oh, put yourself back. I made it in attendance for the first 2 weeks.
Okay, so not last week.
Not yet.
Okay.
Yeah.
Good news. I was here as her. Yeah, she was a witness. So
Okay.
I brought cookies.
There you go. Hey, see, that's all right. All right. Oh. Soothing. Soothing. Chosen not only for its soothing nature, but for the fact that the Wikimedia Commons says it's in the public domain. So I don't know any royalty fees for playing this, apparently. Apparently. All right. It's not a lullaby, is it? Am I putting us to sleep? I didn't want a lullaby. I mean, let me fast forward to something that's not a lullaby. That's still a lullaby. I don't know. I think maybe the whole thing's a lullaby. Okay. Well, it is what it is. Welcome back, everyone. How was the break? Good break? How was the music? I didn't see much dancing. I didn't see any sleeping. That was good. What I'd like to see, however, is our dedicated lead counsel. So if you've been to the website, you've seen the great work that our two author lead counsels have done. Robert, Aparna, where are you? All right. Where's Robert? Not back from the break yet, maybe. Well, you'll get all the praise then. Who will join me in a rightful round of applause for a great outline? Thank you very much. Thank you. Well done. And that helps. It's so helpful. You know, we're trying to study. Robert, that you? Not Robert. I'm trying to thank Robert. I know Robert will be back. So, Robert? No. Robert? He's coming. All right. Tell him thank you. All right. Okay. But of course, there's also our speaker lead counsel, those daring young men and women who say, here I am, it is I, and today it is Alex. Alex, all right. Not too late to change your mind, Alex.
No, sir.
No, in the music industry, they're very generous when it comes to authorship of a song. They have the slang term, change a word, get a third. So maybe you want to change a word on the written outline and you could be the third author of it?
Yes.
Or do you want to be our speaker today? All right, we got a speaker. Let's have a hand for the daring Alex. All right. Alex, let's do this, shall we? All right, you got a book?
Yes.
So do I. You read some of it?
Yes.
Wish I did. I did. I read some of it. Robert? Sorry. All right. I'm gonna find Robert. But I guess I'm on page 187, or at least that's the best I can do without my glasses. Where are they? Man, I know I own a pair. All right. I've noticed if I just hold the book way out, I could usually kind of read it. All right. This is a local attorney, well known and respected, so I'm always embarrassed that I don't know how to pronounce her name. Ayala? Surely you know her, you can correct me. Ayala? Is that right? Did I get it right? Hope so. My apologies if I didn't. Ayala versus Scott. This is a Supreme Court of the state of Florida decision from 2017. And Alex, what was going on here, man?
Basically, the state court of the Ninth Judicial Court got rid of quo warranto.
Oh, I like the Latin. Well done. That's next week. Writ of quo warranto. It's extraordinary writ. You file it. It's an original suit, so it's not an appeal, but you file it with an appellate court. And we'll have all the details next week. But go on, Alex. You're doing great so far. Go on.
It challenged Rick Scott, Governor Rick Scott at the time. It challenged his authority under statute 27.14 to reassign prosecution of death penalty eligible cases and denied it to the state attorney to the Fifth Judicial Court.
Can a state's governor do that? I mean, Miss Ayala, I want to get the pronunciation right. Miss Ayala, she's not an appointee. She's been elected by the people, is she not?
Yes.
And she's the state attorney, right?
Yes.
But yet the governor is reassigning her cases against her will to a different state attorney? Why?
Well, although the prosecutors of the state have discretion,
Mhm.
prosecutorial discretion.
That's right, they do have prosecutorial discretion. I'm stumbling over the words. You're not. You're doing well. Go on.
The governor still has to hold up the laws of the state, and one of them is that the prosecutor should exercise discretion, but
Yeah.
also must pursue the death penalty.
Okay.
That's it.
So the problem, the issue here had to do with the death penalty. What is Miss Ayala, I hope I'm pronouncing that right, proposing to do differently about the death penalty in her district, the 9th Judicial Circuit?
Take it out completely, because the communications should have the death penalty.
She says no death penalty in the 9th Judicial Circuit. For those of you who are familiar with the state of Florida, we're a death penalty state. We trust the government, who seems to screw up everything else with the issue of life and death. Yeah. So they can't run this program right. They can't quite get that system right. Driver licenses, they got that all screwed up. But who lives, who dies? Yeah. They can decide that here in the state of Florida, right? Yeah, but not on Miss Ayala's watch, correct? She held a press conference, did she not? She's fairly newly elected at the time. She's got a promise for her constituents that she's not going to pursue the death penalty. Why does the governor have a problem with that?
The governor has a problem with that because he would like to have justice served, and the governor has a duty to.
Yeah, it goes back to that Article 4, Section 1, Subsection 1, faithful execution of the laws, right? The governor, for better or for worse, is arguing, hey, this is the law of the state of Florida. I am bound by the Constitution and the oath I took to it, to the faithful execution of the laws of the state of Florida. The laws of the state of Florida say this is a death penalty state. Miss Alea, as the chief prosecuting officer of her circuit, says she's doing something more than exercising discretion on a case-by-case basis, that she's just not pursuing the death penalty no matter what. So the governor files this writ of quo warranto with the Supreme Court of the state of Florida. He wants to remove every death penalty eligible case from Miss Alea's jurisdiction and have it decided by the Fifth Circuit, I think it was. Now, the governor doesn't purport to say that the Fifth Circuit must pursue the death penalty. The governor says that the Fifth Circuit has promised to consider the death penalty. The governor says, the Fifth Circuit says, and the Fifth Circuit's prosecuting attorneys will exercise discretion on a case-by-case basis, which is what the law of the state of Florida is, says the governor. So these are the arguments in this case. Alex, how's it turn out, man? Who wins it?
Governor Rick Scott wins it, and Jefferson's cities did not.
Yeah. So the governor prevails.
You misunderstood the law when you said that all discretion necessary, you doesn't have to ever do the death penalty or anything about it.
Yeah, that's the holding of the case. The Supreme Court said, we uphold, do not contradict, and recognize that prosecutorial discretion exists under Florida's Constitution and in the state of Florida. And says the opinion, Ms. Alea could, on a case-by-case basis, exercise that discretion. But, says the Supreme Court of Florida's opinion, that's not what Ms. Alea did. In the Supreme Court of Florida's opinion, Ms. Alea has announced a blanket rule, which is more than just exercising discretion. According to this opinion, therefore, the court is not, and the governor is not, interfering with Prosecutor Alea's discretion because she's not exercising discretion. She's adopted a blanket rule, which is contrary to the laws of the state of Florida, or so says this 2017 opinion of the Supreme Court of Florida. But that leads us to our notes and questions to consider. Alex, you'll stick with me, man, right? How long will you stick with me? How controversial can I get? You can handle it?
Sure.
All right. I respect that. But I'm not going to leave it all on your shoulders. Let's all pipe in here. Let's get a good conversation going. Note 2, if I can read it without my glasses. If anybody sees my glasses, let me know where they are. Oh, I see them. Oh, man. There we go. All right, now I can tell you what Note 2 says. In light of Alea versus Scott, what is a Florida elected official who holds the power of discretion as part of their elected powers supposed to do when faced with a law that the elected official finds morally repugnant? Mind if I say the S word for a minute? Subsidiarity. What is subsidiarity? We talked about it in so many lectures. It is respect of the higher sovereign for the authority of the lower sovereign. Not to quash and step on the coattails and crush the authority of the lower sovereign, but to allow the lower sovereign to have its area of authority, always coming to the aid of the lower sovereign for the overall good of society. That's a terrible paraphrase of what Pope St. John Paul II phrased so very well. You're probably sick of that quote by now. You may have even memorized it by now. But where's the subsidiarity here? Did we have respect for the lower sovereign? One argument would be no. Miss Alea has been elected by the people. She's carrying out the mandate of the people as voiced by their vote for her. The other argument could be yes. Subsidiarity is upheld here. The people have spoken through the legislature of the state of Florida where the death penalty has been enacted, and the law says that Miss Alea has her sovereign authority on a case-by-case basis whether to impose the death penalty, but not the authority to essentially create a new law that applies to her Ninth Circuit and her Ninth Circuit only. These are two different ways to argue the proper application of subsidiarity here. But the question is, what's an elected official supposed to do when faced with a law that the elected official finds morally repugnant? Let me make that hard question even harder to answer. My fellow lawyers, what are you supposed to do when faced with a law that you find morally repugnant? I see some hands. Yes.
I'm not even gonna try to say her name, but in this prosecutor's case,
Yeah.
she should not have held this press conference. If she never said anything, it would have never been an issue because she's using her judgment on a case-by-case basis.
I like the air quotes there.
By-
Did everyone see the air quotes?
By looking over the case facts and seeing, oh, this is the case I would look at.
There you go. So the flaw you see is in the openness.
Yeah.
She held a press conference. She was open about the fact that she's going to exercise her discretion in every case against the death penalty. You're saying loose lips sink ships. You're saying don't ask, don't tell. You're saying keep quiet about your intent. What do y'all think of that? Is that the right answer? Alex, your hand was up. Basically, say the same thing. All right. BJ, you're either combing your hair or your hand's up. You were combing your hair, but now your hand is up. Thank you for playing along. Okay, because the questions only get more difficult from here.
But
So,
I think that's like for me personally has been a difficult navigation is separating like my moral beliefs and like what I think is right or wrong, and then zealously upholding the law as it stands.
yeah, those can be two difficult tasks, right?
Right, so I think if you take the oath to zealously uphold the law, you have to take that 100%. Now, obviously, in private practice, you have the ability to take or not take a case, but
Yeah.
in this scenario, it's a state appointed person, so
Right.
I kind of feel like you're 100% in or you're 100% out. Like,
So BJ says you're either 100% in or you're 100% out. Yes, your hand's back. Yes.
Yeah. Respectfully, I disagree with that opinion because
Okay.
you're upholding the law by prosecuting the case. Your
That's true.
method of prosecuting the case is different in each situation.
Yeah.
If someone's found with, if two different people are found with 5 pounds of marijuana, you might be seeking 5 years for one person, only 1 for another based on the facts of the case. So while it is, she's doing a blanket rule that she's not going to seek the death penalty, maybe she doesn't think that the death penalty is right for any case. So, that's the same thing as she didn't think that, 5 years was right for the person she chose 1 year for. So
Yeah.
you're still upholding the law just in a different way.
Yeah. Yeah. And I see your point there too. Who else wants to chime in on this? It's a difficult issue. Yes.
So does that mean that I get prosecutors elected who don't prosecute crimes that I don't like?
Well,
Say I'm,
there are accusations that there are
say
special interests that are doing just that.
I'm a serial carjacker. Does that mean if I make enough money and put enough money into getting in a prosecutor who doesn't prosecute carjacking?
How about that? You're a serial carjacker. Maybe a financially well-off serial carjacker, so you use some of your money for lobbyists to make sure you get elected prosecutors that don't want to prosecute carjackers. Wow. Wow, that really starting to sound like corruption instead of morality, right?
Because they should be left some amount of discretion.
Mhm.
What amount of discretion they
What's the limit of discretion? Where do
get. Who
we,
decides?
who decides the limit of discretion? Yeah, yes.
Well, that would be completely different, having no prosecution of a certain type of crime than they were just not gonna kill this person for doing this.
So you see the carjacker example as different
Yeah, that's.
than what is happening in Alea versus Scott.
But how do you-
Ayala versus Scott.
decide that discretion? It's still prosecutor discretion. So just because you see that line as being the difference in the penalty that's handed down versus not prosecuting at all, like how do you get to draw that line?
Well, no one gets to draw the line in the legislature.
Okay, the legislature said that you have to consider the death.
Yeah. The legislature didn't say that you have to consider the death penalty. They just said that they are eligible for the death penalty in this case.
Right, it has to be considered in the case.
Well, it doesn't say that it has to be considered. This case says that it has to be considered. So this judge decided that it has to be considered.
The two of you are at an impasse. Who wants to chime in with their opinion?
I think like on a less controversial issue, let's say that the government can grant you up to 5 acres of land. And
Uh-huh.
I'm the person that gets to grant it or not grant it. I
Okay.
think 5 acres per person is ridiculous and nobody deserves 5 acres. So all my rulings, I only do up 1 to 4. I don't think it's my place if the state says that that's an option for me to decide, well, I'm smarter than the state and the Constitution and everything that's set up ahead of me, the people that elected me, that made that Constitution, and I'm taking that choice away from them because I personally have just decided that's never okay.
Right. So you see a problem with rule of law versus cult of personality. Yes.
This is a prosecutor, not the judge or the jury.
Okay. So you see that it's not that
It's
because you see a different role. Is that what you're saying?
Totally different role. They're deciding what they want to pursue, with their discretion, is their lives. And ultimately, if the jury can decide something completely different
Yeah.
within the constraints of the law.
Right.
So
So just because it's charged doesn't mean it'll happen.
exactly.
Yeah.
It could be, and also it's sentencing, like Alex was saying, as opposed to charge itself.
Yeah.
So in what they ultimately are convicted.
Yeah.
So it's not a, I don't think think a lot of these comparisons are apples to apples comparisons.
Okay, so, and you see some big differences here with some of these. Okay,
Yeah,
Yeah.
you're not the ultimate, this isn't like, the ultimate adjudication that's going on right here. It's not,
this is just the charge. This is not the conviction.
Right.
Yeah. And your hands up.
Prosecutorial discretion has been discussed a couple of times, and it reminds me of the police officer I know that irritated me because he said every time that he pulled somebody over,
Uh-huh.
he was writing a ticket.
Every time.
Every time.
Nobody got a pass.
Doesn't matter.
You're 20 miles an hour over the speed limit. You're 10, you're 3. You're 1 mile an hour over the speed limit. You're getting a ticket.
I can't hear it. Sorry.
Sorry, I'm talking over everybody. I'll let y'all speak. Go ahead.
The issue with that was that he made a predetermination before knowing anything that was going on. The fundamental issue here with the state attorney is that they weren't exercising prosecutorial discretion. They made a blanket statement rather than looking at the situation. And that's what I think gave the court the ability to have a good reason to kind of move the case over to a different attorney. Now, I also don't think that the politics of it should be coming in and, just because an attorney is doing what one particular government leader wants, that should be the reason why. But if prosecutorial discretion had been exercised, then I think this would have a bigger argument for not moving the case to the different attorney.
Yeah.
But it has to be exercised from the beginning.
Go ahead. Go ahead. You wanted to
I
respond?
just, that analogy is, I'm sympathetic to, because I understand how discretion issues can happen. However, in that scenario, there's a probable cause issue. If a police officer is already predetermined that they're going to write a ticket, they're not acting within the constraints of the law. They do not have the discretion to do that. So if they're trying to utilize discretion to just already decide that they're going to write a ticket, regardless of whether or not they even know they have probable cause, they're not acting within the scope of their authority. You're not giving them a lawful ticket.
Yeah.
Here, that's exactly what she's doing. She's acting within the scope of what she's allowed to do, and there's no constraints there that are explicit. Probable cause is an explicit requirement for writing that citation. So I don't.
Yeah.
She's
Yeah.
acting within the scope of what she's allowed to do.
Yeah.
Based on that.
Well, at least when it comes to this particular fact pattern, and this particular issue is applied to those facts, we have an answer under Florida's Constitution because we have a decision from Florida's highest court interpreting the requirements of Florida's Constitution and saying that under these particular facts, this can't be done. And the governor can step in, has the statutory authority to reassign cases, and is within the governor's discretion to exercise that statutory authority for this reason because of the governor's constitutional obligation to implement the faithful execution of Florida law. So, and we can agree or we can disagree under these facts, but we have an answer under these facts. The harder question is, how do we apply that scenario to similar scenarios, and how do we apply it to our own practice? And if that question wasn't hard enough, check out note 3. Ayala versus Scott involved an elected prosecutor's discomfort with the death penalty. Florida law grants a prosecutor the discretion to seek the death penalty for crimes of first-degree murder, felony murder, capital drug trafficking, and capital sexual battery. The laws of many nations forbid the use of a death penalty, and the beliefs of many faiths are troubled by the use of the death penalty. For example, the Catechism of the Catholic Church is quoted, and I have a few slides about that here. This first slide is a quote from one of my heroes, St. Pope John Paul II. This is a quote from 1995 from his papal encyclical Evangelium Vitae, which is Latin and translates to, I believe, the gospel of life. And there he talks about governments and says governments, quote, ought not to go to the extreme of executing the offender, except in cases of absolute necessity. Today, however, as a result of steady improvements in the organization of the penal system, such cases are very rare, if not practically non-existent, end quote, said St. Pope John Paul II back in 1995. So back in 1995, I don't know how old you were back then. Back then, the Pope observed that such cases are very rare, if not practically non-existent, and uses the phrase, ought not to go to the extreme of executing the offender. So what was the church saying? And pundits or good-natured, good-faith commentators came to conclusions such as this from 2015. Quote, while the Catholic Church does not condemn the death penalty as intrinsically evil, because of the Church's high value of human life, the circumstances under which the death penalty is morally acceptable are rare, end quote. Says commentators such as Bill Pyatt in his excellent law school casebook called Catholic Legal Perspectives, quoting from page 185 of the second edition. So is that a fair summary of the Catholic Church's position, at least as of that time? Well, I have no reason to disagree. But let's look closest now at the Catechism of the Catholic Church. On our way to the quote of the Catechism, we stop briefly with a quote from Pope Emeritus Benedict XVI. At the time, he was Pope Benedict XVI. And in his 2011 apostolic exhortation called Africae Munis, he says, and I quote, I draw attention of society's leaders to the need to make every effort to eliminate the death penalty. My hero, Pope St. John Paul II, used phrases such as ought not. My other hero, Pope Emeritus Benedict XVI, uses phrases such as every effort to eliminate. And now, as we look at the current text of the Catechism of the Catholic Church, some language of which commentators such as Mr. Pyatt, who we just had on the big board as a quote, did not have the benefit of because this exact language wasn't exactly there at the time. In 2018, Pope Francis approved the following new draft of paragraph 2267 of the Catechism of the Catholic Church. This goes on for 3 slides. Bear with me. It's long, but it is certainly worth hearing. Quote, recourse to the death penalty on the part of legitimate authority following a fair trial was long considered an appropriate response to the gravity of certain crimes and an acceptable, albeit extreme, method of safeguarding the common good. Paragraph 2267 goes on. Today, however, there is an increasing awareness that the dignity of the person is not lost even after the commission of very serious crimes. In addition, a new understanding has emerged of the significance of penal sanctions imposed by the state. Lastly, more effective systems of detention have been developed, which ensure the due protection of citizens, but at the same time, do not definitively deprive the guilty of the possibility of redemption. Consequently, the church teaches, in light of the gospel, that the death penalty is inadmissible because it is an attack on the inviolability and dignity of the person. And she works with determination for its abolition worldwide. That's a quote from paragraph 2267 of the Catechism of the Catholic Church as amended in 2018. That is a call for reform. That is a call for the church, for you and I, to be thoroughgoing and to work with determination for the abolition of the death penalty worldwide. Our moral answer is clear. We, the church, must work for the abolition of the death penalty. Our moral obligation as a great profession is clear. The direction the law must take is clear. Our role in forming that law into a particular direction is clear. We must work with determination for the abolition of the death penalty worldwide. We cannot say on the one hand that this life is worth living and that one is not. We cannot say that there can be no further chances at redemption for the accused. We cannot say it is morally wrong that any life, whether criminal or non-criminal, whether young or old, whether in utero or outside the womb, is too inconvenient and is not welcomed in this world. Together as a church and as a great profession, a lawyer's calling is clear. A lawyer's calling is to choose life, whether that life is innocent or that life is guilty. So that wraps up our coverage of this chapter and leaves us with 15 minutes or 20, depending on how long you'd like to go on, where I can answer questions for you about our midterm exam. First, what's the midterm look like, McGinley? 20 multiple choice questions. Hey, does that mean it's easy, McGinley? No, it is outright impossible. I have over the years, and I've been teaching since 2015, received very polite emails after my exams pointing out to me, in the opinion of the person who sent me the email, that it was the most difficult law school exam they had ever taken. Is that all ego on my part? I hope not. I hope it's also out of a certain necessity. This required class that you're taking has a required curve. I can't give more than 10% of the class a score of A, A minus, B plus. When I add up the total number of A's plus the total number of A minuses plus the total number of B pluses, I can't exceed a certain amount. I believe it's 10% of the class. And on a tangent, what's the deal with the A minus? What's with the minus? Is it like, hey, you got an A in the class, but I wish you didn't, so A minus. I understand the A minus. I very rarely use the A minus. If I see a statistical need for the A minus, but otherwise I watch out for the A minus because it seems spiteful. Is it 15%? It's a small percentage. It ain't 50%. I know that. There's a cap. There's a cap on the A's, A minuses, and B pluses. Now, your exam will be graded anonymously. I won't know whose exam got what grades. So as well as avoiding the A minus, because it seems spiteful, I'm also going to avoid any sort of personalities. I'm not going to give you a better grade because I love you and a worse grade because I hate you. I don't know who I love. I don't know who I hate, but it's not factored in because I don't know who's exam. I don't know who's I'm grading. So it's anonymous, but you knew that. But why the difficulty level of the exam? 2 reasons. First is that curve. What if I gave so easy an exam that everyone got either a 99% right, 98% right, or 97% right? I got to give what, D's to the people who got 97% right? That's awful, right? So I make the exam at a higher level of difficulty. For one, because of that curve. And the second has to do with the learning. You know, I know this isn't your favorite topic. I know that you probably wouldn't write books about it in your spare time, even if you had any spare time. I know that it's a required class and either most, if not all of you, are only here because it's a required class. I know that you don't plan on being a constitutional lawyer in the future. That's fine. But there is valuable information to be learned in this class, especially for those who might take the Florida bar exam. So I do want to inspire you to learn this information at the highest level. That's the other reason my exam is so difficult. What's with this slide? I don't know what that is. I don't know. But that's the other reason why the exam is so difficult. So study and study well. Don't be fooled by the format of the exam thinking that it's easy. And most of all, if you get the highest score, if you book the exam, please know that you earned it because it was difficult. I was blessed last week to have lunch with a student of mine from 2015 who had booked the class and now is practicing in that field. It wasn't state con law. And it's been proudly on the student's resume ever since. And student could be right, student could be wrong, but the student thinks that the student now who's a lawyer is really on top of the game in that field because they learned so much in the class. And the credit doesn't go to me, the credit goes to the exam, the difficulty of the exam. That student wanted to ace the class. That's why the student aced it. That student learned the information. So maybe that can be you. There are a lot of different fields where state con law just pops up and rears its ugly head. Whatever field you might be in, you might need state con law. So study and study well. What's on the exam? If I covered it before today, it is eligible for the midterm. How best do I study? We've got several ways for you. I've recorded every lecture, every word out of my mouth, believe it or not, is available on the internet. And you can listen to me run my mouth again. You can rewind. There's a button you can hit for transcript. That's up to Google. They fall a little bit behind sometimes, but for most of my lectures, the transcript is there, so you can read along with it. You might even copy and paste the transcript into an outline. Our lead counsel very often has given us an outline. That's on our class website, flaconstitution.com. Download it, read it, take advantage of that. Also on our website, flaconstitution.com, is every slide that's ever been on the big board. It's there in paper format. You can read it on screen. You don't have to print it. Don't kill a tree. You can read it on screen. You can learn from there. The book itself, I hope, is well written. I hope. Lord knows I tried my best to give you a well-written book. So hopefully you can turn to that to study from. But I think the most powerful way to study is to try to move from memorization to application. What do I mean by that? I never read a book called The Paper Chase. It's a book about law school. I never watched a movie called The Paper Chase. It's a movie about the book about law school. But I saw a little clip on YouTube once of a scene from the movie of The Paper Chase, which may or may not be in the book because I never read it. But the two main characters have locked themselves up in a hotel room. And the hotel staff is just disturbed. Why haven't we seen or heard from these two students in days? They barge in despite being told not to come in. And it's been an odd situation anyway, because before they checked in, they said, move this television out of here. We don't want a television in our room. And they come in and there are papers scattered everywhere. These individuals have been working day and night. They've been studying the material by quizzing one another. Okay, what's the standard of law. Okay, what about in this hypothetical then? What would be the outcome? What if I change this fact? What would be the outcome? What if I change that fact? What would be the outcome? They were so dedicated as to move from memorization to application. It's a good lawyer who can memorize the law and accurately regurgitate it to you. It's a great lawyer who can tell you what that law means and how to apply it into your daily life. I hope my exam is designed well enough so that the better score goes to the great lawyer versus the good lawyer. So you want to move past memorization and get to application. How do you do that? Maybe you do it alone. I always studied alone when I was in law school. It seemed to work best for me. Like the guys in the paper chase, I made sure that television either wasn't in the room or wasn't turned on. The one exception was when I was studying for the Florida bar exam. It was the Olympics that year, and it was volleyball, which, other than football, is one of my favorite sports. I remember just looking down at the bar review materials, realized I hadn't flipped the page in about an hour because I was more entertained by the volleyball than I was by the bar review material. Don't make the same mistake. If you love football, you love volleyball, put it aside long enough to study the material and find a way to focus on it. But in your focus, move past memorization to application. Because that's what you're going to do when you're a lawyer. Whether you're a negotiator or a litigator, an advisor or a judge, it's always application. Yes?
I also consider the management. How long do you have to wait the exam?
Yeah, I didn't say that, did I? Yeah, I know I gave a generous amount of time, more than you'll need. It might be 2 hours. Allow me to send everyone an email with the exact number on there. Sorry that I don't have it on the tip of my tongue. Because that's an important question. The question was, how many minutes do I have to take the exam? I will send you an email letting you know how long. So, however long you got, use it. Use it. Yes? I'm sorry that I didn't hear you. What'd you say?
She's asking me not questions.
Oh, the number of questions. No, my fault. 20 questions. Multiple choice. Yeah. Yes. Yeah, I know. I need to email her with the exact number of minutes. I'm tempted to say 2 hours, but I don't know that. And I apologize for not remembering. That really should have been on the tip of my tongue.
So no essay whatsoever.
Not on the midterm. Yes. Oh, no, I didn't talk about the essay, but the syllabus reminds us that it's not severe.
Right.
After you get the midterm behind us, I will send an email with the materials. You can find a little oyster, so you've got a backpack that's based on a couple of old newspaper articles or local website articles. And then you're gonna peruse the Constitution. Yeah, it's gonna be fun. It's gonna be fun. But the essay only comes in grade, the midterm is 20%. You guys are surprised. Yeah, what about the midterm first? Yes.
For clarification, is it up until today, like is it including today?
I'm not today.
Not
Yeah.
So don't forget about it.
Yes.
This was all 2019 final exam, all I can say is on the website.
Oh, okay, yeah, you're referring to the FLAconstitution.com website, and then you go to fall 2019, and you scroll down, you look for a picture of like a man's business suit on a coat hanger. What's that have to do with this? I don't know, but there, that's what the picture is. And you can click on that, you can see an old midterm. And I guess it's helpful for practice, you might want to look at it. You'll notice that there's some topics on there from 2019 that are no longer covered. So, but that's all I got, yeah, and it's on there. Everybody hear where to find that? Yes. You didn't hear it. Okay, on the website, FLAconstitution.com, there's this semester, there's fall 2021, but that, some of the old semesters on there. And the oldest is, what, 2019?
I know the limit says more.
Oh, yeah, okay, so you got different buttons, fall 2021, 2020, and finally there's a button that says more. Punch that one and it's got a drop down list. And the oldest one of the drop down list, punch that. And scroll to the bottom, so you see a men's suit on a hanger. Again, I don't know why men's suit on a hanger, but there it is. And that'll give you the answer key to that old midterm. So I'm not promising to cut and paste from that midterm onto this one. I'm not promising to not cut and paste from that midterm onto this one. But you'll notice that some of the questions on the midterm are topics that we didn't cover. Either didn't cover yet or won't cover.
Wait, so how many?
The classes evolve over time. Any substantive questions about farm economy? We still have to get that. Yeah. We're gonna change that. Is that? Yeah. You know, it's hard to take that word time and say.
I was laughing because like the whole team has.
It's hard. So I take questions not only on format, but also on merits. I can answer substantive questions, substantive law questions. Yes. Administrative questions, I can answer those. Yeah, I guess I should pick a cutoff date for that. How about tomorrow? Yeah. So, and you know, I gotta say, I'm always interested in hearing from you, and I'm always interested in helping you learn. But you're right in asking for a cutoff date because, you know, somebody emails me an hour before the exam and gets an answer that I couldn't share with everyone else, then they have an unfair advantage. So thank you for asking the question, and a response I'll pick tomorrow. But I was going to pick tomorrow anyway because I was sending everybody an email anyway. You had nothing to do with my pick. You had nothing to do with it. No reason to hate that man. Haters got to hate, but don't be a hater. Yes. Yeah, we think. Okay. I'm sorry to disappoint. I'm sorry to disappoint. Any other questions for me? By the packing of the books, I'm thinking the main question is, can I leave now? The answer is yes. And until we meet again, may God continue to bless us all. Thank you for being here. Thank you very much. Thank you.